Hey everyone. As some of you may know, I take a mild interest in the legal system, and I have an odd chromosome that causes outrage when I see injustice. Hi, I'm Diana Davison. I've talked about prosecutorial misconduct a bit in the past. You know, when a prosecutor with all the resources of the state behind them railroads an innocent person or tramples their civil rights in order to secure a conviction. Here's a nice little quote from an article by Brad Reid, Senior Scholar, Dean Institute for Corporate Governance and Integrity, trying to explain why this is so important. The U.S. Supreme Court, in a famous 1935 decision, Berger v. U.S., wrote in a unanimous opinion, "The United States Attorney is the representative not of an ordinary party to a controversy, but of a sovereignty whose obligation to govern impartially is as compelling as its obligation to govern at all." Right? So if we have a government, it must follow a few freaking rules, and whose interest, therefore, in a criminal prosecution is not that it shall win a case, but that justice shall be done. Now, Canada, amazingly, shares this view. I say amazingly because Canada has turned to shit in terms of civil rights lately. Carrying on. As such, he is in a peculiar and very definite sense the servant of the law, the twofold aim of which is that guilt shall not escape or innocence suffer. So remember that thing about how important it is to not imprison innocent men? And that's what he's talking about. He, the prosecutor, may prosecute with earnestness and vigor. Indeed, he should do so. But while he may strike hard blows, he is not at liberty to strike foul ones. It is as much his duty to refrain from improper methods calculated to produce a wrongful conviction as it is to use every legitimate means to bring about a just one. So let's look at what we mean by prosecutorial misconduct. Here's a recent case from California involving former prosecutor Robert Allan Murray. Murray added 2 lines to the transcript of a defendant's statement to law enforcement to make it sound like he had confessed. He then gave the transcript to the public defender. 9 days later, and after the public defender confronted his client with the confession, Murray told the public defender he'd made the alteration. Murray defended his actions by claiming he was playing a joke on the public defender. The Superior Court and the Court of Appeal found that Murray intentionally altered the statement to influence plea negotiations. The State Bar Review Department agreed and rejected Murray's explanation. Well, hey, it was only 2 sentences that he added, right? And it was just a joke. So what happened to this guy? You'd think something pretty severe, considering California just passed legislation to make prosecutors more responsible for corrupt actions, leading to wrongful convictions. As Matt Ferner reported on October 1st of 2016, California prosecutors who knowingly withhold or falsify evidence can now be charged with a felony and go to prison under a law signed Friday by Governor Jerry Brown. Further down says, if prosecutors intentionally and in bad faith alter, modify, or withhold any information, knowing that it's relevant and material to the outcome of the case, they could be punished by 16 months, 2 or 3 years in prison, depending on the severity of the violation. So what happened to Mr. Murray? Well, he got a 1-year suspension, and that was only after the Bar Association increased the judge's sentence from a mere 30 days. No jail time. We're talking about a man who falsified the accused's statement to include a false confession. All right, I'm going to give the U.S. a major bonus point here over Canada. In one of the very few articles published by the Toronto Star, which I think have any journalistic merit whatsoever, written by Jacques Gallant, we're told the CLA, that's the Criminal Lawyers Association, has complained for years about what the organization sees as a lack of investigation by the Law Society into Crown attorneys' conduct and a lack of public discipline hearings for them, the kind of hearing any other lawyer in Ontario must face when slapped with discipline charges. Defense lawyers have noted that some of their colleagues have been disciplined in public for fairly minor conduct, including being rude and discourteous to other lawyers and in court. Mustakalis said the Law Society has previously told the CLA that a main consideration is the fact that the Crown Attorney's employer, the Ministry of the Attorney General, already has an internal discipline process. But as noted by a previous Starr investigation in 2014, that's how long we've been trying to get attention on this issue, the ministry's process is secretive, and the government was unable to say at the time how many complaints have been lodged against the province's nearly 1,000 prosecutors and how many had been recently disciplined for misconduct. One of the projects I want to pursue is how often prosecutors in Canada secure a conviction by posing the aptly named forbidden question that reverses the burden of proof, namely asking a defendant why their accuser would lie. I want to find out how many convictions have been secured using this known forbidden question. If I do so, will we ever find out what was done about it? One recent case I discovered with this forbidden question is especially bizarre. I came across it because the case cited R versus Orrar. This case, R versus Orrar, is the most insane feminist decision ever written in the world and soon to be overturned on appeal. So this case cited an insane judge, and I thought, well, I gotta get me some new insanity, so I went and checked it out. The case is called R versus MB. In paragraph 110, the judge says, I also note that there was no suggestion of a reason, that is, a motive, for MJ to fabricate this evidence. While not an essential element, it is a factor to be considered. Well, actually, no, Your Honor, Justice Thomas A. Bealby, you can't consider that at all. In fact, putting this in your reasons for judgment, combined with citing one of the most controversial decisions shortly after publication, please note, Your Honor, that you are the only one to have been that stupid. But I say that with all due respect. Now, I tried contacting this man's trial lawyer, but got no response. If you're a lawyer or can find out who the heck this poor man is, get him an appeal. Alright, back to prosecutors who screw up. One of the biggest problems for an accused is when the prosecutor does not give full disclosure to the defense. Basically, they can get a warrant and subpoenas and fund investigations because they got all the money of the state. But they don't tell you, the accused, when they find something that indicates innocence or might defeat the case against you. And here's the ridiculous part of this problem. How do you, the accused, know what they haven't told you? It's near impossible. I can tell you, I've been working with the falsely accused just for the last year, and I'm constantly finding things that prosecutors or police haven't provided to the defense. Police notes never match what was said in an interview, and it's all the stuff they didn't write down that usually holds the key to proving the person is lying. I'm going to finish with a case from Oakland County in the U.S., but it was reported by Canadian Lawyer Mag, so those who think that the U.S. and Canadian law systems don't overlap or don't care what's happening over the border, well, listen up. The prosecutor in this case refuses to apologize, saying, "Over my dead body." For years, Julian Wendrow searched for a way to communicate with his severely autistic daughter, Aslan, and thought he'd struck gold with facilitated communication. FC involves a facilitator who guides the hand of a person otherwise unable to communicate over a computer keyboard, spelling out what she means to say. Well, what a great dad. But what does he get for all of his effort? The facilitator claimed that Aslan revealed sexual abuse by her father. Wendrow was arrested and held without bail, and an absolutely shocking example of prosecutorial misconduct was just beginning. Police, prosecutors, and child welfare officials never once questioned the efficacy of facilitated communication, and suggestions that another facilitator be used to see whether Aslan's allegations would be replicated were ignored. So Wendrow's entire family was ripped apart by these allegations. He was arrested and facing prison time for abusing the daughter he loved so desperately that he tried to find a way to help her speak. The only state official who showed any skepticism about FC was the judge. When the matter finally came to trial, Aslan's facilitator was asked to leave the room while simple questions were asked of the alleged victim. This came after the prosecutor attempted to have the facilitator wear noise-canceling headphones while the questions were posed to Aslan. Headphones, which, as it turned out, would have made it easier for the facilitator to hear the questions. Upon her return, she facilitated complete gibberish in response. So, how does the prosecutor feel about this? Does he feel stupid? Does he feel contrite? The charges were dropped, and the Wendrows are back together and pursuing legal action against the authorities. The West Bloomfield police were quick to settle, but prosecutor David Gorsecia remains unrepentant. In a 2009 interview with the National Law Journal, he said he would issue an apology to Wendrow over my dead body. So apparently the Wendrows got $2 million in a final court settlement in 2015. But how do we stop this from happening again? I'm Diana Davison, and I want to stop wrongful convictions. Lawyers and people who profess to care about our legal system need to be speaking out about this. But if they won't do it, I will. Support the Lighthouse Project and help me stop wrongful convictions. Stop saying someone should do it and start being the one who does.